followed by Representative Hewitt.
Thank you, Mr. Chair. Good morning, Attorney Kane. You talk about saving the state money. I'm wondering how that will show itself. So are you talking about if we were to do what you wanted, we would actually be able to make a cut in your budget, or would it just flake out over time?
That's right. Well, it would take out time for it to be, for the habeas system. You know, it could be a bubble of new cases, as Representative Gonzalez said. Maybe all of a sudden a flood of petitions will get filed. I don't know if that's true or not. I would hope that lawyers are conscientious in not filing petitions unless there really is some merit to those petitions, although history hasn't said that. What it would allow us to do is reallocate resources. I wouldn't say, okay, I just gave a figure of $4.3 million we're spending on habeas reform. I certainly wouldn't want you to say, okay, we're going to enact habeas reform and whack $4.3 million out of our budget.
I wouldn't expect you.
And I won't do that. I'm not going to do that. We need to allocate those resources to the front end of the system. We need to be able to deal with cases when they come into court, to screen those cases, as we talked about with domestic violence this session. We've talked about dealing with sex offenders. We've talked about the need to devote prosecutorial attention to cases early on, both in the investigative stage of cases and in the screening of cases when they first come into court. We need to take the resources from the back end, put them in the front end, and will that save money in the long run? I think it might. Because then we'll be prosecuting those cases that need to be prosecuted. We'll be diverting those cases that should be diverted. We'll be able to analyze them carefully. We won't get caught into the potential trap where the system just becomes a processing system, where cases are just moved along because people don't have enough time to address them early on and just process them through their first diversionary program, or it's a first offender, so we're going to do this without really looking at the merits of the case. We need to do what the Division of Criminal Justice has to do, and is enforce the law and assure justice. And by devoting our resources to the tail end of the system, we're not doing the job right. So is it going to save $4.2 million? No, it's not. Is it going to serve justice? Yes, it will serve justice in many ways. And will it prevent us from diverting more resources from the front end to the back end and cause an even worse problem as the system grows? It will enable us to do that. We're right now having to cut prosecutors from the GA courts. We're having to not provide prosecutors to deal with domestic violence cases or dedicated domestic violence dockets, which are a good thing, and because we're devoting so much resources to the tail end of the system in this habeas process.
Thank you for your answer. I mean, to me it seems a little less certain in the way that it was coming to me initially, but I want to move on. You said if wise minds sit around a table with the desire to fix the system, we would have better outcomes. But you come to us today with a bill.
Yeah.
And you come to us also talking about your way of thinking this weekend, and how you've thought about because of some circumstances, you've thought about other fixes we could put into the bill possibly. And I would consider you a pretty wise mind. I may disagree with you sometimes, but you come to us with the bill already.
Yeah.
And yet you characterize the people on the other side as simply not wanting to do this. So you come to us with the bill and you admit that you're thinking about, well, there's some things we haven't thought about. That's a little bit troubling to me, because what we're talking about here, we may call them frivolous or whatever the word we choose to use, but 12 people with their convictions overturned is pretty important to me.
Absolutely.
And so I don't know that it's that people just want to oppose this. I think it's that those 12 people otherwise might be in prison. I think that's something to keep in mind when we're talking about this in terms of money, which you've just admitted you're not sure we're going to save. Which, if those 12 people were in prison, the people who were their victims might feel as though they've gotten justice but didn't really get justice. I think that's something important to consider when we talk about this.
Absolutely. Now, I didn't mean to brand the opponents as being blind opponents. That's unfair, and if I said that, I was unfair. There are conscientious people, and it is a need to address this issue carefully, as I think I said in the beginning. We need to craft this properly so legitimate claims can be made. Now, those 12 people, those 12 petitions that Linda Howe just said granted, those are new trials. Those weren't actually innocent people. The actual innocent people I think we've had were I think there's four. Tillman, Miguel Roman, Kenneth Ireland, and then there's a fellow named Miller. There's Miller way back. Miller versus a warden was another one. Those are, in my mind, are four actually innocent people who should have been. You can't preclude their getting relief.
My point, Attorney Kane, is that one is enough for me. It doesn't have to be 12. It doesn't have to be 156.
I agree with you. Absolutely, I agree with you. It's a travesty to convict somebody who's innocent, and one is absolutely one too many. I'm not saying that. And that's why we need to allow adequate relief for people who have legitimate claims of actual innocence, and then be able to have room to argue as to what claim is actually legitimate or not. That sometimes is a determination that has to be made depending on that case. But we need to screen those out. Just think of this, too. The actual innocent person who's filed a petition who can't get this petition heard because there are so many other petitions in the court. How long that person will be delayed in seeking relief on an actual innocence claim that really is meritorious on its face, but is caught in a sea of claims of people claiming their lawyer didn't do a good enough job in convincing them to plead guilty. The system as it exists now is preventing those legitimate claims from being addressed, and not only is causing a certain amount of callousness, the potential for this certain amount of callousness to exist to say, this is one more claim. We can't have that. We have to have a system where legitimate claims are raised, and this demands concentration not only by the change in the law. The law isn't going to fix it. The judiciary is going to have to focus on it more than they have and more carefully, and I think they're about to. And petitioners' lawyers are going to have to function on it. I don't know how many claims are raised on habeas petitions where the petitioners' lawyers come in and believe in their own hearts and even have said so. I think Linda Howe can give you many examples where the lawyer's saying, well, I don't believe in this claim either, but my client wants me to raise it. And they're raising it for no other reason than their client wants to raise it, and they can't tell their client, this claim is not legitimate, is not meritless. So they go on and put on a hearing. And we have loads of time when witnesses are called back to address these meritless claims. It's weeding out, finding the proper way, and I said that at the beginning, I think this is a difficult job, but it can be done, to find a way to weed out the meritless claims so that those claims that have merit are allowed to proceed and allowed to be addressed. And do it in such a way as to not make that window too narrow.
Right. And I don't want to keep going because I know others have questions and we need to move along. I just would say that being legally meritless or not having a claim of actual innocence still does not mean that someone might not, in a real world sense, actually be innocent. So I appreciate the work you're doing because I do think that we need to take seriously a serious look at what we have for habeas corpus. I'm just concerned about moving too fast on either end, and I thank you for your work. Thank you, Mr. Chair.
Because